to, as it were, wrap up the point that I was busy with. As I said, the argument just took us there, fortunately, but just so that I don't go back to it, which was the issue, one of the what I call the peculiar points, which are specifically only raised by the applicant, Ms. Mon, and that was the issue of the nolle prosequi. In my respectful submission, the response that I gave to one of the justices about that covers the why that point is not a good point, and why the nolle prosequi clearly, at least once it was clarified at our insistence by the NPA, that it is wider than merely referring to, then that point, with respect, should have just been abandoned. But it's being pursued nevertheless. And this is despite the fact that the NPA received legal advice. And this is really, this also goes to the question of costs, the kind of cost order that we should be entitled to here, which should be punitive in nature. Because it's one thing, it's understandable, with respect, my ladies and my lord, that Ms. Mon, and now let's not even talk about her lawyers, let's just say as a lay person who's not a lawyer, it's understandable that she could say, oh, here's this nolle prosequi, but where's my name in it? I mean, the lawyers should have explained it to her, obviously, but I'm putting the lawyers aside. But once it has been explained that, no, a nolle prosequi is not read like that. The reason why Section 7 insists that the DPP concerned must specifically say, in fact, whether she specifically says it or not, it is deemed that she has read the complaint, the complaint, police complaint, the affidavit, and all that. Why did the law say that in Section 7(1)? Because it did not want these kinds of situations where an accused person comes back and says, no, my name is not there. And we say, no, it was in the statement. And then the DPP says, oh, I didn't read the statement. By the mere act of releasing a nolle prosequi, she is representing that she has read the statements, and she knows that there are many suspects. So all I'm saying is that once all that was clarified as between the attorneys and the new certificate, the clarificatory certificate was issued, that point should have been abandoned at that point. So from that point onwards, which is the 21st of November, the costs of pursuing that particular point should be visited on Ms. Mon on a punitive scale, and even her attorneys, because they themselves should also have said, okay, well, this point maybe was a good try, but now it has expired. And that goes to something very significant. And it is that it's another point which I think we can get rid of very literally in 5 minutes. Another non-point. You'll remember that both applicants raised the Section 7(1) point of saying that former President Zuma has no peculiar interest or injury suffered as a result of the alleged crime. I mean, really? Can you say that? Remember, for the purposes of this point, you have to assume that everything is true. You have to assume that his medical information, as a person, forget that he's a former president and all that, and that because of that, in any event, his information is protected by secrecy acts and all sorts of things. Forget that. Assume this was just Mr. Tembam Kize down the road. Can anyone really with a straight face say that the dissemination of the private medical information of that person is nothing? What are they talking about? They are not suffering any injury. When that person says, I specifically withheld some of this information, even from my children. I specifically made sure that nobody knew, at least I didn't, and I'm his lawyer. But I didn't know that he was suffering from a life-threatening disease. I didn't. Maybe other people did. I didn't know that there had been an 18 months wait for a particular procedure. I didn't know that. And that is the information that was leaked. And we were told with a straight face that what is it going on about? He hasn't suffered any injury. Quite apart from the fact that that issue in any event should be, it's a matter of title to prosecute. That's vintage Section 106 issue, if Justice Kuhn is to be believed. Mr. Badlander, to the junior, correctly called it a jurisdictional prerequisite as envisaged in Section 7.1. But its absence is a matter of title to prosecute. Because what in simple English, not in simple English, in legalese, what you are saying when you are saying a person doesn't have peculiar interest, you are saying they should be raised in the criminal court. But for the purposes of this argument, let's assume it can be raised here. It has no merit. It is insulting, actually, for anyone to even utter that. It's the height of arrogance and bigotry to say he must just deal with it, you know. So South Africa is not just a signatory to that UN document, but it has been specifically received. So so the duty to act. So the failure of Mr. Downer to act is a crime because he had a duty to act under these guidelines, among other things. But even just under in common sense. Now, the issue, Justice Masipa, is that we allege that, therefore, Justice Downer, Mr. Downer or Advocate Downer sanctioned, by omission, sanctioned or authorized, and in fact he did more than that. It could have been that he just kept quiet and didn't go to the police or whatever, but he actively participated. He's the one, after all, on the 10th, who then told Mr. Breitenbach that I've now signed the document and so on. So again, in the criminal trial, of course, he's going to testify. He can say, oh no, actually Mr. Breitenbach, I don't know, told me that he had the authority of the NDPP. I mean, I don't know. So, but there is no, as we're sitting here now, there's nothing that absolves him from the responsibility he had to work as a witness, Mr. Downer as a witness. And that's what happens in every criminal trial. We all think it looks like this, somebody fired a shot, therefore they are guilty of murder. And when they go to court, they say, no, it was self-defense, whatever. That's not for this court, that's for the other court. The simple question before this court is prima facie on what we have here. Is there this lack of authorization? Is there this condonation, sanctioning, authorization, whatever you call it, by the mere fact of non-action. If the answer is yes, that's it for prosecution. Whether he'll be found guilty or released in terms of Section 174 at the trial is of no concern to this court. So I hope that is behind us. What is it that we are really accusing Mr. Downer of having done or failed to do? Yes. Now, what makes it even worse is the attempt to say that, to tell the lie that when Mr. Downer or Mr. Breitenbach or anyone else in the NPA that we don't know about conspired to leak this document, at that point the document was a public document, and Sanral, blah blah blah, you get told Sanral, the Sanral case applies, and so on. It's a blue lie. Everybody knows that is not true. How do I do that? Because the documents themselves, again, I'm not relying on anything we say, I'm relying on what they say. The conversation was initiated by Mr. Breitenbach. We only discover that when he makes the police statement. All along we were told Ms. Mon made an inquiry, a media inquiry, routine. All journalists make inquiries from all of us. No. Mr. Breitenbach, out of the blue, called Ms. Mon. Ms. Mon was minding her own business somewhere in Pietermaritzburg because he wanted to leak this document. He called her and said, the WhatsApp exchange. Sorry, when I say called, it includes the WhatsApp exchange. It's actually better because we may not know what was said in the on talking. So the WhatsApp exchange actually assists us until the document is filed tomorrow. I'll take you to the thing. So everyone knew that the document will only be filed tomorrow. It was Women's Day on the 9th of August, 2021, public holiday. And therefore they say it's going to be filed tomorrow, obviously, when the court opens. Now you are told stories. So on the 9th of August, it's known to everyone. In fact, again, one doesn't have to be a lawyer or a genius or anything to appreciate this point. Anybody will know it. You ask it in what we call a rhetorical question. If there was nothing wrong with publishing the document before it is filed, then why was that arrangement made? Why was it necessary to say to Ms. Mon, don't publish until tomorrow or until the document is filed? It's because everybody, because nobody gives a document to a journalist and say, no, but don't print it until tomorrow because I must still file it. And then comes here in front of a court of law and say, no, the document was filed. If it was filed, then what was the problem? They know, and they know very well, they're just trying to fool this court and the public into I don't even know what to call it. So it's worse than obfuscation. And that is where the rub is. Because, and remember, by the way, even if the document had been a so-called public document, that only goes to the issue of confidentiality and publication and so on, not the disclosure. The disclosure, we're way past that now. The crime has been completed of the disclosure. and Miss Mon, therefore, whether you look at it as information, which is section 46, I'm sorry, yes, 46(1)(a), 41(6)(a), yes, thank you, 41(6)(a), or whether you look at it as the document, the hard document from Dr. Mdntv, which is 41(6)(b). It doesn't matter, because they breached all those separate statutes. And the document that makes this very clear the version is that Mr. So-called, sorry, Sandal, sorry, that the Sandral case applies because the document had been filed on the 9th, which on anybody's version. And let's put aside now that at 9 o'clock, 9:21:07, Mr. Affidavit was sent at 1 minute past 12, just so that the dates can work here. But it doesn't matter which way you do it. You can either use that analogy, or you can say, let's look at everything that happened before 9 p.m. What happened before 9 p.m. is that the crime was completed, because to everybody's knowledge, the document had not been filed and should not have been used. Now, Mr. Downer, at least to his credit, attached the email tomorrow. And please, Ms. Mon even sends only unfiled, it was uncommissioned as well. But what is worse, Justices, is that so-called affidavit was actually unnecessary. There's no, this was just a vehicle for the leaking of the medical document. When we get to the criminal, these insults about Stalingrad and what have you, we said, no, that's fine. He's in prison, there's COVID, we'll go on without him. In fact, when we argued in this room, the section 106, 1H, he was not even here, because he, not even us, had made that concession to say it's fine, carry on with the matter, even if I'm not there. So there is that arrangement. Justice Kuhn then says we must apply. While we're busy applying, making the application, we must apply. We're the ones who want the postponement. They put an affidavit, a nameless affidavit. I don't know what it is called. Nobody asked them to put any affidavit. To do what? We must apply for a postponement. And then they must do an answering affidavit, and then we reply. That's how it that's what happens in all courts all over South Africa. An affidavit of Ms. Karen Mon. And you'll find what they say is that point, let's call it res judicata point. So they say, no, this was decided by Judge Kuhn, and not only that, it was decided against us. Well, let me tell you something. At least if Mr. Trengove was here, he would tell you what I said standing here. I said, we want to bring to your attention this matter that, which is at page 239, 240, the paragraph in the judgment. You'll see the previous paragraph. For further investigation. And he says, no, I can't do that because Mr. Downer has not had a chance Then he says, apart from the procedural difficulty, I have doubt, that's not making a decision, whether the wide terms of 41.6 are necessarily constitutional. So he raises a whole different point, which is not raised in this matter. I mean, these are the kinds, he's just chatting. Yeah. I would have thought that Section 41.6 would not, would not, for example, prohibit a member of the NCOP. Also been hoodwinked to think that there was an inquiry from a journalist. He didn't know that it was initiated by the NPA. Yeah. To charges or the assistance regarding a particular investigation and other, without the benefit of having heard considered argument. If it is believed that the provisions of Section 41.6 outlaws such conduct, then a formal charge in that regard says that at Section 39.2 of the Constitution, when interpreting any legislation, when developing the common law or customary law, every court, including this one and any other court, tribunal or forum must promote the spirit, purport, and objectives of the Bill of Rights. And those spirit and purport is explained in 39.1 as promote the values that underlie an open and democratic society based on human dignity. Assume everything I've said is wrong. Everything. What the other side does not respond to is the fact that we have another count. We have another crime. Mr. Downer has proven himself to be a serial leakist. He leaked the documents. He leaked them 14 years ago. Or Mr. Downer, this is a conversation he had on the 5th of May, 2008, with Mr. Soul, a prosecutor in our democratic republic. Look at conversation 2, you'll find that at 110. I'll just read it for context. Hello, this is Mr. Downer. Soul. Billy, Sam, can you talk? Mr. Downer, hello, Sam. Yeah, sure. Soul, listen, we got pretty good information that the Germans are in the process of striking a deal with Tyson in Germany. Mr. Downer, right. Probably next week or within the next 2 weeks and so on. And then the next page is, we've written, Mr. Downer now, we've written to them and told them that we know this is going on. I was just gonna say you need to extradite. He says, be careful how you word it. Avoid sources close to us. In other words, be careful how you source it. Avoid sourcing it to the NPA.
Lord, I'm sorry to interrupt, but when last night a learned friend telephoned me about arrangements for today, and he undertook that we would be done by 3 o'clock so that we could have an hour in reply. It's now 3:10. He also repeated that this morning. I'm concerned that we are not going to have an opportunity to reply.
Yes, no, that is true, my lord. Firstly, no, I'm not about to finish. It's right what Mr. Padlender has said. Firstly, I had said in the morning that it was our intention to do so. But as I said, that was based on mainly the time that was left. We've already 10 or 15 minutes extra for the tea and another 15 minutes for the lunch. I don't know. Well, I can't. All the counsel in this matter, nobody has been they argued until they finished. Even the amici, they argued or dealt with the matters that they dealt with. I said myself voluntarily this morning that we are going to, I said voluntarily, we're going to try, and which is why I phoned my learned friend last night, because there's nothing worse than having a matter not finishing. That's why I called him last night. I said we will try to do it within that period. But I'm not a prophet. I didn't know that will be half an hour.
He said we will finish by 3 o'clock, I promise you. That's
yes.
what he said.
No, that is true. And finish at 3, and on the basis that the normal court hours are going to be kept, and that we will start at a particular time. I didn't know that there's going to be half an hour extra that is unaccounted for. Yes, no, I know you've heard me, but I'm putting it for the record. Yes, so it's number one. Number two, no counsel here has been. First of all, no questions were asked from them, and therefore they were able to finish within their time. And don't hear me wrong. I appreciate interaction with the bench, because it's important to if a particular justice doesn't understand or wants to clarify a point. That's not what I'm not complaining about that, but I'm saying that does affect the time as well. So I was assuming that we'll have this come from me. Some of the things seem to be first-hand information, as if he's quoting directly from section 41.6, where it says you may not give information. It must not come from me. They will ask who's talking to the mail and guardian. All right? So that is a separate crime, and anybody, even the most biased person who can say that that does not amount to a breach of section 41.6, then and even if this was a crime that's attributable to a particular city, thanks, that would be a matter to be raised at the beginning of the trial before the criminal court in terms of section 106 1F. Secondly, section 106 1F is the only exception to the rule. You look at section 106 4. Yes, 106.4. You know, I'm sure the court knows, goes to our jurisdiction and prematurity point. But B, assume I'm wrong on that. Assume it can be raised here. It's, so what? It's dilatory at best. It will either be heard here or in Cape Town. Okay. Anything else about the issues? So that after that they ran out of lane, so to speak, because those are the only objections, except of course the one that I have to deal with in a hurry now, which cross both of them, the so-called Stalingrad. I don't think it's worth any the paper it's written by our client. We painfully do that, even though he's in the middle of nowhere. Make sure that all the documents here. Anyway, it is said that in the safest place to get this, my lords and my lady, is in Mr. Ngalwana's heads at page 3. It's the case we all know. They're using this because Mr. Ngalwana has quoted the paragraph that we all quote, and then he also quotes the one we're accused of hiding. So, paragraph 37 of the judgment of Haram's DP says, a crime event can only be determined once criminal proceedings have been concluded. Hallelujah. That's what we've been saying all day. It can only be determined at the criminal proceedings, but in any event, it is if there are no probable grounds. I've read from Mr. Soul's conversation, I've read from the affidavit, I've read from the emails to show that this is not a case where you can say probable grounds for prosecuting are absent. By any stretch of the imagination, no person can say that against him. And the sole purpose is the so-called ulterior motive. Then you can, that's what the court said. Why would we not read this, bad as we are, when it actually assists us? And secondly, that qualification, even if it applied here, would not apply because this is a private prosecution. The principle of legality, which is to do so would breach the principle of legality. The principle of legality applies to public bodies. And we were told, wrongly in my respectful submission, but that's a matter that will be determined by the Constitutional Court, because we have appealed that judgment in Gauteng directly to the Constitutional Court. That's how strongly we feel about it. But in that case, here, well, I don't have to hand it up. Your Lordship said you've got it. In the Gauteng case, you'll remember that it was said there that the reason why it's called a private prosecution is exactly because it is private, and therefore the outer principle does not apply. So when it's President Zuma going to the Gauteng court and saying, they want to stop my prosecution, but to do so, they must pass the outer test because they are actually reviewing. They say, no, but outer test, who do you think you are? You are just an individual. Outer test doesn't apply to you. Let's go. The president cannot come. But he's now told, no. The principle of legality applies to you. What is that? What is that? It is not justice, at least. It's Zuma law. And we're not here for that. We're here to ensure that the same standard, the goddess of justice, must be blind. And if we're going to have justice that has eyes here, that determines who is the accused today, who is the prosecutor today, and then the law changes according to that, then woe unto this country. And you know, the members of the public are not stupid. Members of the public know when there's an injustice. They know it. They might not have gone to university like me and my learned friend, Mr. Masuku, and everyone, but they know when there's an injustice. When somebody is incarcerated without having stood in a court of law to say, am I guilty or not guilty, then they know, they say, this far and no further. Anyway, at paragraph, yeah, well, at page 162, sorry, my lord. I'm sorry, my lord. I'm trying to fight fires here. Yes, my lord. I'll come to that. Let me just make this one point. I won't even read. I'm just making a reference. If the court can go to page 162, of the MON documents. Is it? Okay, let me just make sure. Sorry, man. It's 162 of Downer, of the Downer document, yes. It says, this is just the exchange, and I'll just read it. I'm not going to develop it in the same spirit as the conversation with Mr. Soul. This is the email exchange on the day in question, when the crime was committed. Sorry, I say email, WhatsApp, yeah. Mr. Breitenbach, I hope you are well and aren't en route to PMB, Peter Maritzburg. That's 1639. I'm here, 1642, that's Ms. Mon. 1644, 2 minutes later, boom. he sends the Kun J letter of August 2002. There's nowhere where Ms. Mon says, I request a document, all the lies that I was told in this affidavit, that she made a request for documents. Sends Kun J letter. (1646), he sends the Zuma postponement affidavit. And then in the morning, 7:29, sends our affidavit. And then at 7:30, she says, thank you. And then she says, when can I publish this? And then he says, it was emailed to the judge's registrar and the parties last night, so you can do so now. That's what's called knowledge of unlawfulness, mens rea. So he says, because it was emailed to the judge's registrar and the parties last night, and this one was signed, you can do so now. It's wrong in law, but at least it's an attempt. And then she says, thank you. And she says, great. And then she says, I need to wait before I file on Billy, though. In other words, this file now is about filing the story. So she has to wait on Billy before she can file the story. So the story is written on the criminally obtained information, but she has to wait for Billy. Then Mr. Bredenbach says, I'll check with him. If that's not an act of association, nothing ever will be. And remember, he had been told before. And he says, please, otherwise it's just their side. In other words, I'll only be publishing theirs. And Tusini refers to Billy's affidavit. That is leaking information that is in your possession in terms of the NPA Act. And it is a crime in South Africa until that statute is changed. What I will do, no, I have to say this. The Ms. Mon says that they have two ulterior motives. Ms. Mon's ulterior motive is that Mr. Zuma wants to harass and intimidate her from reporting. She's reporting, she's been reporting, as Mr. Masuku said, ever since 2021. I don't know what intimidation. She writes every day on Twitter about Mr. Zuma. Nobody has done anything. The worst thing that she alleges is that somebody called Mr. Mani, who is the spokesperson of the G. Zuma Foundation, not even in that capacity, as himself, as Mr. Mani, just walking in the street, sent a tweet, and Ms. Dudu Sambutla Zuma also sent a tweet. I mean, really. So, former President Zuma must now go around controlling everybody out there, spokespersons and children, about what they tweet. I don't even, he is on Twitter. I was going to say, I don't even think Mr. Zuma is on Twitter. But to the extent that he is, he's not his daughter's keeper. None of us can be imposed with that silly obligation. So there's no intimidation, there's no... Mr. Zuma says, Aigabi, as we say. He says, I don't know the lady. I do not know this Karen Mon. In fact, he was saying to me, even if she came there, I wouldn't be able to point her. So how can I resent her as someone that I don't know? I was told, I saw this thing and I was told that somebody is doing rounds with my information and so on, my medical information. I don't know the person. So this idea that by osmosis, whatever resentment might happen to anybody on Twitter must be attributed to President Zuma is just plain nonsense. Then the other Stalingrad version now of Mr. Downer is that, no, it is to get rid of him as a prosecutor because of the so-called 20 years Mr. Zuma has been evading. I don't know how I describe that one. Firstly, there's no 20 years. The so-called 20 years that gets bandied about, we allow this thing to happen because, you know, the media has got its own mentality. But in a court of law, you can't come and talk about the 20 years. There's no 20 years. The charges were withdrawn of in a particular time. For 9 years or so, there were no charges, and then they were reinstated in 2018, I think, yes. So they count even the 9 or 10 years when there was nothing into this so-called 20 years. And then they lie and say that Mr. Zuma, in all that, he has been unsuccessful in his matters. Well, that's also false. Mr. Masuku has told us that Judge Msimang in this court said that this was politically motivated. Judge Nicholson in this court said that it was politically motivated. But if the answer is going to be, well, okay, they might have said so, but eventually there was an appeal and so on. But I'm just saying judges, sober judges of this country have held in Mr. Zuma's favor. But let's forget about all that. Justice Kuhn, here, sitting here last year on the 11th of April, when we wanted a postponement pending a Constitutional Court appeal, the other side came here and argued Stalingrad. Justice Kuhn rejected it and granted the order in our favor to await the outcome of the Constitutional Court, and rejected, with the contempt it deserves, those are my words, he didn't say it himself, the so-called Stalingrad accusation. So people can go and manufacture their own facts out there, but not. This is a court of law. This is a serious place. It's not a place to come and bring gossip here and twisted spin. So there's no Stalingrad. If there's any Stalingrad, they are guilty of Stalingrad, because as the Stalingrad is either the myopic version that gets described by the chartering classes out there, or the version that was described in a court of law by Wallace J.A. at paragraph 157 of the Moyo case, where he says Stalingrad is the tendency of well-to-do, well-resourced accused persons to escape the consequences of their actions in a criminal court and go to a civil court. That's Stalingrad. That's what they're doing. That's why we're here. They should go back, like all the people in this country, black and white. When they are served with a summons and they say, go to court on Monday, the criminal court, they take their things. It doesn't matter if they think that they are innocent. They go to court, they run the trial, they win or lose. What's so special about them? Why should they not deal like all the millions of accused persons every day in our country and come here and have 3 judges at their request in a civil trial listening to all this, instead of doing that which every South African is obliged to do? Forget about every South African. Former President Zuma. Mr. Downer says he's a prolific litigant or whatever, says that as a snide remark. No, it's not a snide remark. It's a badge of honor. Because unlike some, former President Zuma, for all the years, for every time he's here, day in, day out, if he has to be there in the dock, he's there in the dock. If he has to be sitting here, he's sitting here. He has never sheepishly run away from appearing in a criminal court of law. He is here. He's a former president. He's not you and me or you know. He's a former president of this country. But he comes here dutifully. If he's going to be sick, he sends a note. And for years and years he's been doing that. But no, not Ms. Mon, not Mr. Downer. Let's be serious, man. If we want a country here, let's make sure that we have a constitutional democracy that respects the rights of every citizen, black or white, in the same way, and nobody should have some special dispensation of a civil court. That is what is Stalingrad, as described by Wallace J.A. in paragraph 157 of the Moyo case. And therefore, with the greatest respect, for the reasons that I've explained, I don't have time. If your lordship, maybe just to if your lordship can allow us to, because there are 1 or 2 points, maybe to file a short supplementary submissions on the 1 or 2 points. Yes. Thank you, my lord. As a court, please. I'm indebted to the court.
Lord, could I have an indication as to how long we can argue? Because I will not be done in 15 minutes, and I'm afraid that what has happened here is that my learned friend Mr. Mpofu has argued from 9:30 until quarter to 4. That is in excess. That's approximately 5 hours without breaks. My learned friend Mr. Budlander and I argued yesterday from 9:50 until 12:30. That's 2 hours and 25. But with respect, my lord, my learned friend Mr. Mpofu is not entitled to disentitle my side from a proper entitlement to reply.
Try to explain that to Mr. Mpofu as you heard it, and you saw what the response is.
Well, my lord, in that case, we ask for leave. I can't speak for Mr. Downer, but we ask for leave to file our note in reply. Because with respect, there are points that need to be dealt with. There are arguments that have been made that are entirely without merit, and I would ask that we have permission to use the 15 minutes to go, and that we are then entitled to file a note in reply to Mr. Mpofu's address. That is, I make that request. Alternatively, I ask that you request that the court staff sit late. I make one of those 2 requests, my lord.
That's, with respectfully, I respectfully adopt the same position, my lord. We really, it would be entirely unfair for us to be denied the right to reply.
My lord, sorry, just a few remarks now that if that will be the arrangement.
No, with respect, my lord, I did not invite my learned friend to address you again. I asked for the 15 minutes to address you, following which I would deal with the balance of the points in reply. And for him to suggest that he's now going to make further submissions is, with respect, wholly unprofessional.
My lord. Thank you. 2 minutes.
Very grateful for that.
We are most indebted to your lordship, your ladyships, and indeed the court staff. Thank you.
Do you want to say something, Mr.
Yes, my lord, I was on my feet, but Mr. Badlander chose to insult me. I was still on my feet, and he says my wanting to speak is unprofessional. It's fine. We'll tolerate these things up to a point. I just wanted to say that I don't want to be waylaid by that. Just to say two things. One is Mr. Badlander Jr., at least Mr. Badlander Sr. is not involved in this. Knows that this very thing that happened here happened in a matter where he was my opponent last month, and we couldn't finish a 2-day matter, and we had to come on a 3rd day, and that was arranged. Fortunately, he had finished, and he's junior.
Does this have anything to do with the time you allocated to them?
No, my lord.
Well, then please,
No,
it does not.
it does. No, my lord, I've been insulted. Your lordship cannot allow. I was told firstly that I'm filibustering, number one. And now, secondly, I've been told that my wanting to address the court is unprofessional. If your lordship wants to silence me in the light of those insults without giving me a right of reply that everybody who is insulted in this country has, then I will sit down. But
You can respond
thank you very much.
in the appropriate forum, but not yet.
Yes, well, my lord, I was insulted in this forum. I'm simply saying that if I was told that I'm filibustering, the court did not intervene, which the court should have done. And the court did not intervene when it said that when I want to address it, it's unprofessional. Then what other forum am I going to address him?
Kofi, we're now encroaching on the court's time, the court's gratuitous time. Thank you. We are not having enough time to address the court. And we've heard the submissions and we have read.
Well, my lord, I'm sorry. Sorry, my lord. Yes, no, that's fine. I just want to place on record that I did not filibuster and I did not act unprofessionally. And if anybody feels that I did, they, not me, must go to the appropriate forum.
So noted. Thank you.
As the court pleases.
Thank you, my lord. My lord, I have agreed with my learned friend for Mr. Downer that I will argue first, and we will ensure that we do not repeat each other, and we will ensure that we complete within an hour between us, even if I take 5 or 10 minutes extra. My lord, my ladies, what you have been treated to is with respect a spectacle, because you've had to witness our learned friend for Mr. Zuma accuse this legal team and the other legal teams of lying, of being disgraceful, of being arrogant, of bigotry, of obfuscation, and of subterfuge. And I'm afraid that it became clear what was going on in 2 answers. When at one point your lordship presiding said to our learned friend for Mr. Zuma, we know what the law is on private prosecutions, and you were told, well, you are not the only audience. And later when there was an impassioned speech about members of the public. And I'm afraid that what you have been treated to is not a legal argument. It is a speech for purposes of television. And that is most unfortunate. It's unfortunate for 2 reasons, because what it...
Hello? I'm sorry, I don't want to interrupt my learned friend, but I just want to say, if there's going to be any further trading of insults, then we will require an opportunity to address them at the end. The submissions we made were aimed at the litigants. We never said anything about counsel, but were available if there's going to be that kind of insult. They're not going to be abused here.
Well, look, my learned friend took my next words out of my mouth. What I was about to say is that we are going to resist the temptation to respond likewise. We are going to do what we understand is our duty, which is we are going to focus on the facts and the legal principles at hand. Because with respect, when you focus on the facts and legal principles at hand, it is obvious that there is no defense here, and both applications fall to be upheld. So on that at least, my learned friend and I now agree and I will proceed to deal with the matter as dispassionately and clinically as I can, and to avoid getting drawn in to what has become a rather muddy spectacle. So in that regard, my Lord, I propose to address 5 issues in the course of this reply. Firstly, I will deal with the question of jurisdiction and prematurity. Secondly, I will deal with the point of joinder, which is somewhat extraordinarily persisted with. Thirdly, I will deal with the noli prosequi. Fourthly, I will deal with abuse. And fifthly, I will deal with the injury. In other words, I'm dealing with 2 preliminary points, and then the 3 grounds on which we submit, on behalf of Ms. Morn, the application falls to be upheld. Now, on the point of prematurity and jurisdiction, my Lord, my learned friend begins by saying that the constitutional founders, that's in his words, decided that criminal matters must be decided by criminal courts, whereas civil matters must be decided by the civil court. Well, with respect, my Lord, that's simply not correct. The Constitution doesn't refer to civil courts. It doesn't refer to criminal courts. It refers to courts, and in section 166 it refers to the High Court, which embraces both civil and criminal courts. So the starting premise is plainly wrong on any reading of the Constitution. But it's wrong for a different reason, my Lord. It's wrong for a different reason because the authorities on which my learned friend relies are plainly inapposite. My learned friend calls in aid 2 authorities: the Moyo decision of the Supreme Court of Appeal, which frequent reference was made, and the Tint decision in the Constitutional Court. Now, Moyo, my Lord, was not about this issue at all. What Moyo was about the issue that arises from time to time, which is, can one challenge a statute before that statute has been used against you? Can one proceed to court and say, this statute is unconstitutional because of what it criminalizes, because of what it does to you, because of what it requires for sentencing, or do you have to wait for the statute to be used against you? And the courts have given a range of different answers depending on the context. For example, in Centre for Child Law, and my Lord, perhaps to assist the court, if I could, instead of reading the full reference, I can just give the court a list of the references at the end without argument in writing. But in Centre for Child Law versus Minister of Justice, the 2009 decision of the Con Court, the court held there that a sentencing provision could be challenged immediately. You didn't have to wait for a child to be sentenced. And in Amabungani versus Minister of Justice, the court held that you could challenge RICA directly without having anyone dealt with under that. But in a criminal context, in 2 cases, the courts have expressed concern. Those are the 2 cases referred to this morning: Moyo versus Minister of Justice and Savoy versus National Director of Public Prosecutions. So the issue in Moyo was not about whether you could set aside an abusive prosecution, nor about which court you had to go to. It was about a different question. Can you challenge a criminal statute under which you are charged before you have been convicted? Justice Wallace seems to suggest no. The court in Savoy seems to suggest maybe, but it's very difficult. But it doesn't matter, because it's all entirely irrelevant. Ms. Morn, and indeed Mr. Downer, do not seek to challenge a statute, and so the principle in Moyo and the principle in Savoy are of no assistance whatsoever. The second authority on which reliance was placed was Tint. Tint was a search warrant case, and there the debate was, should you be able to challenge a search warrant in advance and prevent evidence from being put before a criminal court in advance, or should you wait until the end of the trial? And the Constitutional Court said you must generally wait until the trial is going. That's what happened in Tint. We are not in a search warrant case. We do not complain, my client and indeed Mr. Downer, do not complain about fair trial rights. And so Tint is of no assistance. And similarly, the only other authority relied on by our learned friend is of no assistance either. That is the judgment by Mr. Justice Kuhn on the 106 issue. You will recall that you were told in submission that Mr. Justice Kuhn had given a judgment and had said that any allegations of abuse or to stay the prosecution had to be dealt with in the criminal trial. That is not what he said. What he said appears in paragraph 77 of his judgment. The court does not need to go there, but I will give the court the reference. What he said at paragraph 77, and it appears in the Morn papers at page 180. What he said was, if there are complaints about any issue in the trial or fair trial rights, those can be revisited at the end. In other words, he applied the Tint principle. But no one has argued any fair trial infringement in this case. Ms. Morn hasn't, Mr. Downer hasn't, and so the reliance on Justice Kuhn's judgment is patently inapposite. So the three judgments which were put before you, purportedly in support of the jurisdiction point, the Moyo case, the Tint case, and Justice Kuhn's judgment, do not advance Mr. Zuma's case one iota. There is no authority cited in support of that case, which is on point. What about the authorities on the other side of the table, which support the idea that we are entitled to proceed as we have? Well, we have what's been described as the ancient judgment of Solomon, decided in 1950. Well, it was decided in 1950, long before I was born, but thankfully it has now been approved and cited with approval in Phillips versus Buerta, the decision of the SCA, 1999. We've cited it in the heads at 565F. So Solomon is still good law under the constitutional era because it has been cited by the SCA. And Phillips versus Buerta, in turn, was referred to with approval in Mineral Sands Resources by the Constitutional Court at paragraph 77. So is there any doubt that Solomon is still good law? No. So was Justice Sutherland and the full bench in Gauteng incorrect in following Solomon as it did? No. And you've heard no cogent argument as to why they are wrong. We're not going to argue that you're bound by that judgment. That's not necessary for us to do so. The bottom line is it's plainly right. It's right because it follows long-established principles and because the only authorities put up on the other side are plainly inapposite. One last judgment on this score, as if there were any need, but in the judgment dealing with the, in the full bench judgment dealing with the stay application in Mr. Zuma's case, the same issue arose. Because what happened in that case is that there were applications for a stay brought by Mr. Zuma on the one hand and Thales on the other. And one was brought as a criminal case and the other was brought as a civil case. And what happened as a consequence, and we will make that judgment available to you, but it's made clear in the judgment that one was a civil case, one was a criminal case. They were heard together. They were heard together in front of a bench of 3 judges in this division. And of course they were dismissed. And the 3 judges who heard that were Justice Nguni, Steyn, and Poyotlati, as she then was. And when Mr. Zuma sought to appeal, he tried to run this very point. He tried to run this very point by contending, and it's summarized in the judgment on leave to appeal, that the complaint in this regard was that it was an irregularity for the criminal trial to be reconstituted and the application to be heard as a civil trial by the full court of the High Court, as this was contrary to the CPA. The contention was that the application should have been heard before a criminal court constituted as such. So the very argument that is raised here by Mr. Zuma was raised in an attempt to appeal against the judgment of the full bench and the stay application. It was rejected by the full bench, who refused leave to appeal. It was rejected by the SCA, which refused leave to appeal, and it was rejected by the Constitutional Court. So where are we on the jurisdiction prematurity point? On Mr. Zuma's case, no authorities on point, none whatsoever. On our case, a long line of authority dating back to 1950, approved by the SCA in 1999, and the recent judgment of the full bench in this matter. The jurisdiction point, with respect, and the prematurity point, and the subsidiarity point should be seen for what they are, a desperate attempt to avoid getting into the merits. Let's move on. The second point that is raised in a similar attempt to avoid dealing with the merits is the joinder point. The extraordinary point is made that Ms. Morn had to be joined by Mr. Downer, and that because she wasn't, the case is fatally flawed. Let me place on record what has already been placed on record. Ms. Morn does not wish to intervene or participate in Mr. Downer's application. There is no need for her to do so. She has launched her own application, and insofar as she had a right to be joined, she waives that right. I am mandated to place that on record. But we're then told that it's impermissible for that waiver to operate because Ms. Morn still has to be heard somehow, and the example is given of a tender case where you can't not cite the one tenderer because they agree. Well, that's what happens every day in tender reviews. Why does it happen every day in tender reviews? Because it has been our law since 1949 that a party with an interest requiring it to be joined is entitled to waive that right. That is the famous case of Amalgamated Engineering Union versus Minister of Labour. It will be on the list of authorities, and the reference is at 659. There, the appellate division, and this is even more ancient than the previous case, but it's been cited again and again and again. And there, the court said there may also, of course, be cases in which the court can be satisfied with the third party's waiver of his right to be joined, e.g. if the court is prepared, under all the circumstances of the case, to accept an intimation from him that he disclaims any interest or that he submits to judgment. It must be borne in mind, however, that even on the allegation that a party has waived his rights, that party is entitled to be heard. Well, you are hearing me with respect, my lord and my ladies. You are hearing me on behalf of Ms. Maughan, and she waives her right to be joined. Let's move on again. And it's notable with respect that so much time was spent debating those two issues, and the reason is palpable. It's because there is no defense on the merits. So can I now turn to the merits? And the court will recall that there were three different bases upon which Ms. Maughan impugned the summons. The first was the absence of the noli prosequi certificate. The second was the abuse of process doctrine. And the third was the absence of an injury. I'm going to deal with each of them in turn because each of them has not been fully answered and each of them is more than sufficient to set aside the summons. Let me begin with the noli prosequi certificate. Now, the argument on the first noli prosequi certificate is that when you read everything together, when you read the letter from the DPP, when you read this, when you take into account all of the context, you should conclude that the first noli prosequi certificate, even though it referred only to Mr. Downer, actually meant to refer to Ms. Maughan as well. But there are two problems with it. The first problem is that's not what it says. And so what you are asked to do under the guise of Ndumeni, which must be the most abused case in all cases that I've seen, it's cited whenever you need to get around some wording, is you're told ignore what it actually says and think laterally, and you'll find that it actually refers to Ms. Maughan. Well, with respect, that's not the way Ndumeni or any principle of interpretation works, and it is inconsistent with what was said by the relevant official in the letter which I took you to and which I will take you to again. It's in paragraph 18 of our heads, Advocate Zungu writing, "When I took the decision in respect of the aforementioned matter, the suspect under consideration, as expressed by the complainant, was Mr. Downer. Based on the investigations and the evidence, I declined to prosecute Mr. Downer. Ms. Maughan was not contemplated as a suspect." Now that, of course, explains why, and we now understand it, why Mr. Ntanga, in his supplementary affidavit, was at such pains to suggest that Ms. Maughan gave a warning statement, or Ms. Maughan gave a statement to the police. And our learned friend for Mr. Zuma said again and again and again that Ms. Maughan gave a statement to the police. He's trying to squeeze her into the suspect category. But she didn't with respect. And I explained that painstakingly with reference to the facts in my opening address. The facts are she was asked for information, she took legal advice, and she volunteered to give an affidavit to the NDPP. It had nothing to do with the police. I took you through that. There is no answer to that. And so the premise on which it's built, that Ms. Maughan was somehow a suspect, is patently bad, and that argument must therefore fail. So with regard to the first issue, the question of whether Ms. Maughan was mentioned by the first certificate noli prosequi, the answer is she plainly was not. And that is the end of the matter. Because whatever the second certificate says or doesn't say, I argued to you that the certificate noli prosequi is a jurisdictional fact. It had to be in place before the matter began. I pointed you to the authorities in that regard, and there was a deafening silence from our learned friend for Mr. Zuma. Absolutely deafening. You did not hear argument to the contrary, you did not hear authority to the contrary, and what that means is, when this application was launched by Mr. Zuma against Ms. Maughan, and the certificate was not in place, then it was invalid. And that is the end of it. So you don't need to concern yourself with machinations about what the second certificate means, because on the only legal argument before you, without the first certificate being in place, that was the end of the matter. I say again, as I said to you in chief, we could all go home now in respect of Ms. Maughan, because there was no answer to that proposition. That would be the end of the matter. But instead of going home, which I hope we will all do shortly, let me move to the second point, which is the abuse of process. Now, I began on the abuse of process by making 2 points on the principles. And I said that 2 principles were undoubted in our law. The first is that motive was relevant, despite the arguments relying on Mr. Justice Hurrams. And the second is that the merits were relevant. And both of those, I said, were established by the Mineral Sands Resources. You heard no answer to those. So you can now accept that notwithstanding what is said in the heads, notwithstanding what is said in the papers, you can accept as a matter of law that motive and merits are relevant to abuse of process. And that must be so, because that is the law. So can we now turn to deal with the different grounds on the abuse of process? And can I begin with the one on which our learned friend spent the most time? And that was a desperate and with respect, somewhat valiant attempt to persuade you that there actually is a case on the merits here. That actually somehow, if you look askew, you will find there is some case on the merits against Ms. Moore. And this, with respect, at least I will say this is the first time that we've actually had that argument. There's nothing in the heads on that. I made that point to you. This is the first time that we've had an argument which says this is why Ms. Moore and Mr. Downer are guilty. So we are at least making progress, but with respect, the argument is wholly without merit, and let me demonstrate why. I now understand what Mr. Zuma's argument is on the score. Mr. Zuma's argument is that Section 41.6 of the Act must be given an absolute meaning. When Section 41.6b says that no person, without the permission of the NDPP, shall disclose to any other person the contents of any book or document or other item in the possession of the prosecuting authority. Mr. Zuma's case is it means any book, any document, any item. That is the argument our learned friend advanced with great vigor. His argument is that it does not matter whether it is the letter from the doctor, whether it is some other document, it's automatically a violation of 41.6 if it's disclosed without permission. And in fairness, when you read the statute by itself, there might be something to be said for that. But the problem is that, as you heard again and again from my learned friend, for Mr. Zuma, that is no longer how we read statutes. I lost count of the number of times you were told that you had to interpret the statute in context and subject to 39.2 of the Constitution. And on that at least, my learned friend and I agree. The problem for my learned friend and his client is that when you interpret it in that way, his whole argument falls apart. And let me demonstrate that by means of an example. Let's say that the document that Mr. Downer has in his possession is not the letter from the doctor. It's a copy of the Criminal Procedure Act. And Ms. Moore is reporting on a case, and she goes to Mr. Downer and says, Billy, I'd like to borrow your copy of the Criminal Procedure Act, the one that was paid for by the NPA. Please could I do so? I've left mine behind. And Mr. Downer gives it to her, and she writes a piece disclosing it to her members. On Mr. Zuma's argument, he has committed an offense, because that is a document in possession of the NPA. He has given it to Ms. Moore without authority, and he's committed an offense. Or suppose she says, Mr. Downer, I believe there was a judgment that came down yesterday. Why don't you give me a copy of it? And Mr. Downer gives her the copy, and she writes about it. That would be a breach. Now, I see my learned friend laughing, and I'm glad he finds it amusing, because it's so patently absurd that it could never be what the section means. The section is not about every piece of paper that happens to be sitting in Mr. Downer's briefcase, or every document that is sitting on his computer, or every document in his filing cabinet. It is about something else. It is about a document that has not been disclosed to the public, has not been made public, and that has some air of confidentiality. And that's obviously what it's about. Why do I say that's obviously what it's about? Because that is what the SCA told us in the decision in Maharaj versus the M&G. Now, this was not cited in our heads because this is the first time we've been furnished and favored with this absolutist argument. We will give the court, again, the reference. But in Maharaj, the court had occasion to consider exactly the question of how one dealt with Section 41 of the NPA Act. That case was about a Section 28 inquiry. I don't need to deal with the details. But what the court said, and if the court would make a note, I'll give you the full reference on my list of authorities, but what the court said, and if the court could have regard particularly to paragraphs 31 to 34. In paragraph 31, the court said, and the debate was, where there had been a Section 28 interrogation, which is expressly subject to 41, and the MNG was in possession of it and wanted to publish it, would they be committing an offense? Did the NPA have a proper basis to resist? And the court said at paragraph 31, the information in question was already largely a matter of public knowledge at the time the NDPP made her decision. To the extent, therefore, that the interests of others, read Mr. Zuma, would be implicated, there was no longer any basis for confidentiality inasmuch as the information was squarely in the public domain and had been for some time. And then in paragraph 32, where the NPA had said we have to rigidly adhere, never to give you anything in our possession, the court said the NDPP's rigid and inflexible adherence to the policy of non-disclosure meant that she completely lost sight of the fact that the appellants had themselves placed the evidence in the Section 28 proceedings in the public domain. They did so when they annexed the relevant transcripts of their evidence to the court application challenging the constitutionality of certain provisions. As this court observed in Van Breda versus Media 24, a judicial proceeding is a public event and information on the public record may be broadcast despite its highly sensitive nature. And the court cites Van Breda in the SCA. And then it says in the next sentence, in Cape Town City versus Sanrail, it was pointed out that the animating principle, therefore, has to be that all court records are by default public documents that are open to public scrutiny at all times. While there may be situations justifying a departure from that default position, any departure is an exception and must be justified. And then at paragraph 34, the same point is made. So, what the court explained there, to use my learned friend's words, is that a purposive approach to Section 28, to Section 41, is that it is not intended to cover information which is in the public domain. Self-evident. Self-evident. But if there were any doubt on that score, let me assume that you are somehow troubled by that conclusion. I don't know how you could be troubled, because with respect, it's obviously a confidentiality provision. But if you were somehow troubled by that provision, we would commend to you the decision in Democratic Alliance versus ANC at paragraph 129. That's the decision of the Constitutional Court, where the Constitutional Court laid down in words of one syllable how you interpret harsh penal provisions, harsh criminal provisions. Because you heard at length from my learned friend how strenuous the punishment was, the 15 years, the seriousness. Well, what did the Constitutional Court say in DA versus ANC? It said when you're interpreting these kinds of provisions, these are tough provisions, very tough. They show the statute's prescriptions have meaning, and they could operate with calamitous effect on any party who falls foul of them. These considerations point to how we are obliged to approach the interpretation of the provisions. In case of doubt, we are obliged to interpret their prohibitions restrictively. This means that we must resolve any ambivalence in them or uncertainty about the meaning against the risk of being penalized. So even if you read M&G and Maharaj, and you read the sections and you apply logic, and you still think to yourself, does this provision apply to court documents? You would apply the test in DA versus ANC, and the answer with respect is obvious. How could it ever be constitutional or appropriate or intended by Parliament to penalize someone for disclosing a document which was already a court document and was therefore open to the public? Now that is the end of the case, because what that means is that Section 41 has no reach to documents which were filed in court. And my learned friend did not disagree with the chronology which I took you to about how the matter occurred. There was no debate that the first time the letter was sent to Ms. Morn, it had already been sent to the judge for purposes of the proceedings. And the first time it was published by Ms. Morn, it had already been sent to the judge 3 times. Once by Mr. Downer, twice by Mr. Downer, once by Mr. Zuma's legal team. What are we still debating with respect? Unless there is going to be a serious argument that a court document cannot be disclosed without facing 15 years imprisonment, this case is non-existent. It is a mirage. And that's without even getting into the debate about whether it was Mr. Breitenbach or Mr. Downer, which I don't propose to get into, because it doesn't matter. It just doesn't matter. So where are we on the abusive process? Well, on the merits, the case is not just weak. It's hopeless. It's non-existent. It is a mirage. What about the other points that we made? Mr. Zuma's personal animosity to Ms. Morn. Well, you're told Mr. Zuma doesn't know Ms. Morn and wouldn't recognize her, but he was prepared to describe her under oath as being a racist bigot. With respect, I didn't say he knew her and his views were justified. I said he had animosity to her. When you call someone a racist bigot under oath, that normally classifies as some degree of animosity. Was that 5 more minutes? Thank you, my lord. Mr. Zuma's true purpose in bringing the private prosecution, well, I've said all I can about that. The suggestion that Mr. Manye is somehow distant from Mr. Zuma when he's speaking on behalf of Mr. Zuma's foundation is simply extraordinary. We've made our point. I don't need to make anything further. And lastly, on the question of Mr. Zuma's attempt to mislead this court, you've heard nothing. We argued in great detail on the basis of the replying affidavit that Mr. Zuma's annexure put up to say that Ms. Morn had deleted the tweet and that this was evidence of a guilty mind was false, that it was manufactured evidence, and that it was an attempt to mislead the court. There was no further affidavit, despite what is said in the Competition Commission case, which will be part of the list, and there was nothing in response. Nothing. Not a word. And it's no answer to say that my learned friend ran out of time. He didn't run out of time, and I would have thought that given the importance of this issue, it would have been worth addressing well within the first 5 hours of his address. So where are we on the abuse? We have a meritless case, utterly, utterly meritless, brought against a journalist who has reported critically on Mr. Zuma, who bears a personal animosity to her, and who attempts to mislead the court to show that she has a guilty mind. I say again, if there is no abusive process in this case, then none exists. The last point on this before I turn to the injury, the suggestion somehow by our learned friend Mr. Ngalwana that the court is getting in the way of private prosecutions, with respect, his examples from Canada and New Zealand just demonstrate the point. Private prosecutions in other countries are not allowed to go unhindered. In most other countries, there is some sort of court scrutiny before you even get off the ground. Our legislature didn't require court scrutiny, but it did require certain requirements to be met, and they have not been met in this case, and there was plainly an abusive process. So very lastly then, on the injury question, with respect, the injury question was one that caused particular outrage, that it was said that that demonstrated arrogance and bigotry that it was persisted with. With respect, of course it's persisted with, because it is a point that is plainly with merit. And could I demonstrate this? My learned friend says, well, he didn't even know that Mr. Zuma had been waiting 18 months. He didn't know that Mr. Zuma had a life-threatening illness. But the problem with the argument is that it always conflates other facts with what is actually revealed by the letter. And I would ask the court to go and reread that letter. And I would ask the court to consider whether there is truly any disclosure of private medical information there. And in doing so, I would ask the court to have regard to what Mr. Justice Kun said, because it's true that Mr. Justice Kun did not decide the Section 41 issue. But what he did do is he made remarks about whether there had actually been private medical information disclosed. And I would ask you to have a look at page 247 of the Morn bundle, paragraph 265, where Mr. Justice Kun says the letter is vague and general in terms and does not disclose any particularity which could be said to be a violation of Mr. Zuma's rights to privacy. And in fact, even in the argument in the 106, even in the argument on the postponement, our learned friend Mr. Mpofu said much the same. If you have a look at the Downer affidavit, which is at 689, paragraph 66, when Mr. Trengove complained, Mr. Mpofu replied, well, let me say this. Mr. Trengove says they are in the dark. Well, they are in the dark. They are in the dark. It's not a coincidence they're in the dark. We're all in the dark. He knows that the exact medical condition of the accused is a matter of confidentiality. So I don't know if he expected the doctor to go into that kind of detail in this letter. So Justice Kun knows that there's no detail on the medical thing. Mr. Mpofu knows that from what he said to Justice Kun. What are we still debating about the kind of injury that justifies this? So we submit with great respect that on each of those three grounds, the absence of a certificate, the abusive process, and the absence of an injury, the prosecution against Ms. Morn falls to be set aside and interdicted. You did not hear one word about why an interdict was inappropriate, and we submit that both the setting aside and the interdict are appropriate. We also persist in seeking punitive costs. And you did not hear any argument as to why the punitive costs were inappropriate. They plainly are. And the statements that have been made today to say that these arguments smacked of bigotry and arrogance and the rest just make it worse. But you don't need to go there. All you need to say is that this was a hopeless prosecution from the outset, It should not have been persisted with when the application was launched, and the fact that it's been persisted with has led Ms. Maughan to incur unnecessary costs. And we ask for an order dismissing upholding the application and with a relief in the notice of motion, including attorney-owned client costs and including the costs of 2 counsel. My Lord and my ladies, I am indebted to the court and the court staff. Those are Ms. Maughan's submissions.
My Lord and my ladies, us will be similarly brief. I hope briefer. The first matter I want to address is the rules, the complaint, the Rule 7 complaint. The State Attorney can't represent Mr. Dana. Now, one has to turn to the rules. We know what rules say. Mr. Zuma says he brings this complaint in terms of Rule 7. He says so in his answering affidavit. You then turn to Rule 7. Rule 7 says a complaint of this nature must be raised within 10 days after you're aware that the person is acting, or on a longer period on good cause shown to the court. In other words, you can go to court and say, I couldn't do it in 10 days for the following reasons. Please allow me to do it now. That was raised in the replying affidavit. So Mr. Zuma was on notice that his objection to the State Attorney was invalid. It was stillborn because he had to comply with Rule 7. So what did he do? Did he then comply with Rule 7 and bring an application for a late filing of a Rule 7 notice? No, he ignored it. And what does his counsel say when he comes here? He says the court should also ignore it. Well, that's not how the law works. Our learned friend made an impassioned plea for equality before the law at the end of his submissions. The rules apply to everyone. They apply just as much to Mr. Zuma as to everyone else in the court, and he can't just ignore them and ask the court to ignore them. In any event, so the Rule 7, there is no valid Rule 7 complaint. In any event, I referred your lordships and your ladyships to the findings of the Supreme Court of Appeal in the case about Mr. Zuma's legal fees. And I trust the members of the court will remember what happened. There Mr. Zuma's private attorney had been paid by the State Attorney. And the court said there's no justification for it, no basis for it, and it then went on to say whether there would be a basis for the State Attorney itself to represent Mr. Zuma would depend on the facts of the case, the nature of the case, the nature of the interests, the public interest in the case, the government's interest in the case. All of those would have to be considered, but they weren't in the Zuma case because it was all done to a private attorney, which was unlawful to start with. If Mr. Zuma had in this case raised the objection to the State Attorney properly, he would have had to file an affidavit. We would have filed an affidavit by the State Attorney who explained why it was in the public interest and in the government's interest for the government to be represented, or for the State Attorney to pay. The National Director of Public Prosecutions would no doubt have filed an affidavit explaining why an instruction was given to the State Attorney to represent Mr. Dana. None of that happened because they don't follow Rule 7. And why don't they follow Rule 7? Apparently it doesn't apply to them. So the Rule 7 complaint is really without substance at a formal level, and it's without substance at a substantive level. Then on the question of non-joinder, I'm not going to repeat what my learned friend from Ms. Maughan said. May I just read what was said? He quoted a 1949 case. Here's the 2015 case. It's called Fluxmans, Fluxmans versus Litos Corporation, Lithos Corporation. And the reference is 2015 2 SA 322. 2015 2 SA 322, a decision in the Gauteng division. Paragraph 30. In summary, I'm now reading the judgment. In summary, where a party has a direct and substantial interest in litigation and has been given formal notice of such litigation and waives the right to be joined in the circumstances amounting to a consent to be bound by the judgment, such joinder would no longer be necessary as the principle of res judicata would operate. And so that's the short answer, and for the sake of completeness, let me say that refer to the court to page 3 of the record in the Dana case, where you will see that the papers were served on Ms. Maughan's attorneys. So she was given notice of it, and she elected, very sensibly not to participate. That brings me to the third point, which is the argument about the charge against Mr. Dana, which appears to be a charge of being an accessory after the fact. And I say three things in that regard. Firstly, if you want to know what the prosecutor's case is, you look at the summary of substantial facts. And there tells you what is the case that the prosecutor is going to make. And it's done in this case. Can I refer the court to the Dana record, page 52, paragraph 44. It may be helpful to go there. It's page 52, paragraph 44. And it's in the summary of substantial facts and after a recitation of other facts, paragraph 44. Now therefore both accused, that's Dana and Morn, unlawfully and intentionally, without the authority of the National Director or such person designated by the National Director, respectively, authorized the disclosures. Well, let me stop there. The court knows that Mr. Breitenbach, that Mr. Dana did not authorize the disclosures. He tells you that, Mr. Breitenbach tells you that. So you know that he's not guilty of that. He didn't authorize the disclosures. Authorized the disclosures and disclosed the information and or content of the document. Well, you also know that Mr. Dana didn't disclose the document. He neither authorized the disclosure nor disclosed it. So the case of Mr. Zuma is utterly without any factual foundation. You know as a matter of fact, on the facts before you, that Mr. Dana didn't authorize the disclosure and he didn't disclose the information. And that, with respect, is the end of the case against him. The case is simply fanciful. The second thing to say in this regard is that in this case, this is a case in which Mr. Dana alleges that the prosecution is obviously unsubstantiated. The answer to that must be to substantiate it. But there's no attempt by Mr. Zuma to substantiate the complaint against Mr. Dana, the accessory after the fact complaint. There's nothing at all, no evidence put up, no suggestion that any evidence even exists, undisclosed evidence. It's simply silence. Mr. Dana says there is no case against me. There's no evidence against me. Here's the evidence. Mr. Zuma says nothing. The third point I want to make in relation to the accessory after the fact issue is to take the court back, if I may, to what is an accessory after the fact. An accessory after the fact, according to Lawser, volume 11, 3rd edition, paragraph 136, an accessory after the fact is a person who, by his or her intervention, after the commission of an offence, assists the perpetrator or accomplice in evading detection of and prosecution for the offence. Assists the perpetrator or accomplice in evading detection of and prosecution for the offence. That's what Mr. Dana would have to have done in order for there to be any case against him at all. There's no allegation of that kind whatsoever in the papers. The case goes on and says, the Lawser goes on and says, mere failure to report the commission of an offence or mere approval of an offence is not in itself sufficient to render a person liable as an accessory after the fact. And that's what Mr. Dana is alleged to have done. He's alleged to have approved of what Mr. Breitenbach did. Well, whether he approved or not is irrelevant. It doesn't constitute an offence to approve. It doesn't constitute an offence to know about it. It constitutes an offence to do something to prevent the detection and prosecution. And the cases cited, there are 8 cases ending up with the 1998 case in the Supreme Court of Appeal, all explaining the same point, that the offence consists of assisting the perpetrator or accomplice to evade detection and prosecution. There is no allegation in the summary of substantial facts. There is no allegation in the answering affidavit. There is no allegation even in the heads of argument, not that you could make it there, that Mr. Dana has done anything of the sort. So the charge is simply, with due respect, nonsense. Receiving information is not a crime. Receiving stolen goods is a crime, but receiving information is not a crime. It's not a crime known to our law. Receiving information that a crime has been committed is not a crime. And so Mr. Zuma and his counsel, with respect, can't just make up the law to suit their case. They provide no authority whatsoever for the proposition that just knowing about it and doing nothing about it, which is their complaint, constitutes an offence. Then the next next matter is a related matter. It is, our learned friend says that Mr. Zuma is not going to prosecute Mr. Breitenbach, who was the source for Ms. Morn, is not going to prosecute Mr. Breitenbach. He's going to call him as a witness, and he's on the list of witnesses. Well, the court knows what Mr. Breitenbach is going to say. The court knows that Mr. Breitenbach, when he's called as a witness, is going to say that Mr. Downer did not disclose the medical letter. He's going to say that Mr. Downer did not authorize him to disclose the letter, that he did it off his own bat. And so, if that's the evidence on which Mr. Zuma relies, his case is sunk. It's finished. His own witness, and he says he's going to rely on, who's the person who is not calling, he's not prosecuting him because he's a witness, is going to sink him, because he's going to tell the truth, which is that Mr. Downer did not disclose and he didn't authorize. That brings me sort of patlangs to why then is Mr. Breitenbach not being prosecuted? The reason with respect is obvious, because prosecuting Mr. Breitenbach will not assist, will not advance Mr. Zuma's cause, which is to delay the prosecution. If Mr. Breitenbach is prosecuted, and if he withdraws from the prosecution team, somebody else will have to be appointed. It will have no effect whatsoever on the prosecution, and so it won't cause a delay. So why bother to prosecute Mr. Breitenbach? Because it's not going to help in the strategy, and that's why we have this strange thing that the person who did disclose is not charged; he's a witness. But the person who didn't disclose is charged with disclosing, which he didn't do, or authorizing, which he didn't do. So that, with respect, is the end of the accomplice, the after the fact, accessory after the fact. My learned friend has dealt with what Justice Kuhn said about the disclosure of the doctor's letter, so I don't have to go there. Then I come to the United Nations guidelines on the role of prosecutors. And that is, again, an extraordinary argument. The argument appears to be that A, Mr. Downer did not comply with the United Nations guidelines on the role of prosecutors, and B, therefore, he's committed a criminal offense. That's what I understand the argument to be. Certainly that's how I heard it. Our learned friend shakes his head. Well, as the court may have heard it the same way as I heard it, I'm going to persist in that. That Mr. Downer didn't comply with the UN guidelines, and that a failure to comply with the guidelines is a criminal offense. Both of those statements are false. Firstly, Mr. Downer did comply with the guidelines. It's set out in paragraph 60 of our heads of argument. It's all fanciful because, anyway, but it's set out in paragraph 61 of our heads of argument. The paragraph 13D of the United Nations guidelines authorizes prosecutors to disclose matters that are necessary in the performance of their duties or when the needs of justice require such disclosure. One of their duties is to ensure that the public is kept informed of what's going on. We want not just a lively press, we want a well-informed press. And so it was within the scope of, it was part of the performance of Mr. Downer's duties that he spoke to Mr. Sol, and well, he didn't deal with Ms. Morn on this in any event. So the first problem with Mr. Zuma's case is Mr. Downer did comply with the guidelines. The second problem with his case is that you will find nothing in the NPA Act which says that a failure to comply with the guidelines is a crime. What it says is that the NDPP, it's dealt with in paragraph 61 of our heads, in section 22(4)(f) of the NPA Act requires the NDPP to bring the UN guidelines on the role of prosecutors to the attentions of directors and prosecutors working for the NPA and to promote their respect and compliance. There's nothing in the Act. That's where the UN guidelines are dealt with. There is nothing in the Act which says a prosecutor who does not comply with the guidelines is guilty of an offense. It's a very strange attempt to find, because there's no because no offence can be found under the NPA Act, Section 61, an attempt is made to import it there. There's no such thing. Then, almost finally, I make the submission briefly in light of the fact that my learned friend has addressed it more fully. There's only a token attempt in oral argument to answer the case that this prosecution is an abuse of the process of court. There's nothing in the heads of argument which deals with it substantively. It's dealt with briefly in passing, and there's no real answer to it in argument. I ask the court to go back to the founding affidavit and to read the founding affidavit, paragraphs 18 to 34. That tells you the timeline, the sequence of events, the sequence of the litigation in which Mr. Zuma has been involved, most of it at his instance, not at the instance of anybody else. It's paragraph 18, which starts at page 10, goes on for pages and pages, and it ends in paragraph 34 on page 16. I asked the court to just read that and then say, no abuse of process. How could one possibly reach that conclusion? My learned friend, Mr. Mpofu, complains about the statement in our heads of argument and in our oral arguments that Mr. Zuma has been unsuccessful in all of his matters. Let me read you what is in the founding affidavit. At the same place where I was a moment ago, it's now paragraph 35.2, page 16 of the founding affidavit. This is what Mr. Downer says, quote, he says, I highlight the following features of this timeline illustrative of Mr. Zuma's abuse. Quote, all his challenges have ultimately failed, but only after he had pursued them to the bitter end. Close quote. That's the allegation made by Mr. Downer in his founding affidavit. If you turn to the answering affidavit, I won't take a quote there, it's paragraph 43, page 236, that's not denied. Now, I wasn't, this is the first time I'm involved in this case. I haven't been involved, blessedly, in the previous litigation. So when I was briefed with this, one of the things I went to check was, is it true that all of his applications have failed? And I found the founding affidavit, where it says, read it again, all his challenges have ultimately failed. And I turn to the answering affidavit, Mr. Zuma does not deny that. He doesn't say, oh no, you've forgotten about Judge Simon, or oh no, you've forgotten about this. It's not denied. So we're entitled to say that, because it was alleged and it was never denied. Then, finally, on the question of the foreign jurist, I was going to make some remarks about responses to what Mr. Ngolwana said, but in the light of the lateness, I won't do that. What I will do is just say something briefly about the reliance on the foreign jurisdictions. The relevance of the foreign jurisdictions is not entirely irrelevant, because here we're interpreting the NPA Act and the CPA. But the one thing that emerges from the foreign authorities, all of them, is that they all have safeguards to prevent the abuse of private prosecutions. And the need for it is obvious, because a private prosecutor, by his or her nature, has an interest. It's somebody who has a grievance, a personal grievance, and he's coming and wants to be vindicated. And so they can't be expected to be, in the words, to be independent, and they can't be expected, in the words of the Constitution, to act without fear, favour or prejudice, because they're interested parties. They have a grievance which they want to pursue in the courts. And so there are systems to prevent abuse. And in Canada, the system which Mr. Ngolwana said he loves, there's a prior pre-trial process before a judge who decides whether the matter may proceed. Everywhere, there's a mechanism to prevent abuse of the power to prosecute privately, because it is a power which is inherently at risk of abuse. In our country, there are two mechanisms to prevent an abuse. The first mechanism is in Section 7 of the Criminal Procedure Act, which sets out the requirements for a private prosecution, the interest and so on, and a non-prosecutor certificate. The second safeguard in our country, in our law, is that the courts watch what happens and they will intervene to stop an abuse of that power. They will do that through the doctrine of abuse of process. They will do it through, they have done it again and again and again and again. They have done it in the civil courts, and they have done it because the courts are alert to the fact, and they refer to the fact in the various judgments. They say this power can be abused. A business person can use it, can prosecute his competitor to try to put the competitor out of business. These things have to be avoided, and so the abusive process doctrine is there to protect against the abuse of the private prosecution power. And who has, and all we ask in this case, and all we ask, and sorry, so the abuse of power doctrine exists inter alia to ensure no abuse takes place of the private prosecution power. And if the court finds it's an abuse either because it's for an ulterior purpose like delay, or because there's no case anyway, then the court intervenes, it sets aside, and it stops the private prosecution. That, my lord and my ladies, is what we ask this court to do. Thank you.
Yes, my lord.
I read your heads on a point that you want to raise in mention there.
Yes.
You still feel the need to say something?
My lord, if I may take 2 minutes to do so, with your leave.
Yes, I certainly object, my lord and my ladies. If she's given an opportunity, her request for time to address the court was on the basis that I would address the issue of whether or not she should be their admission as amicis should be revisited. That was the only basis on which she would ask for more time. She cannot now, late in the day, come up to try and address the same question. But if the court grants her the right to reply, I would ask to be given an opportunity to respond to what she says.
Thank you. My lord, if I may just address my learned friend's latest statement. It is not so that I requested an opportunity to address this court only if Mr. Zuma was opposing the admission of the amici. What we heard this morning was a different argument, and it was an argument which I addressed this court had an implication for the procedure. The point is this: Mr. Zuma consented to the admission of the amicus. Yes, but my lord, with respect, I haven't addressed the point that I wish to address this morning, which is a point about how this argument has been transmogrified. It has become an argument about why you mustn't take the Helen Suzman Foundation submission seriously. And that is a very serious submission to make.
The belief that you sought related to whether Mr. Masuku was right in trying to convince this court that you should not have been trained as an amicus in the first place. That's not the only basis. The only basis here past that.
My lord, as I addressed your lordship and ladyships this morning, the issue had changed. The issue had become a matter of process because they ran arguments relevant to the partisanship of the Helen Suzman Foundation in seeking to persuade this court to give less weight to those submissions. And my submission was those are only relevant to admission. So in fact, there is an argument which we still wish to address to this court. We beg an opportunity in the late day to put in further written submissions, if we may, on the topic. Thank you, my lord.
My lord, my lady, we are in the same position and we simply align with the Helen Suzman Foundation submissions. That's the court basis.
Are we adjourned or is that big time?
Okay, I trust you.
get a chance, could we also respond to the Downer submissions on Galwana's submission? Because we don't know.
Thank you.
I'm going to the airport.
You'll be fine.
Which is what you guys checked in.
But these are mine. Yeah, just this because I've managed to take them. I tried to take away your pens. No, those ones are, that's authorities and what have you. We don't need that. This time I'm going to leave. Yes, I'm good. Let's go past this.